to attend our session today. It's a long time coming. We've done a lot of work to get ready for this presentation, and I'm excited to share the information that you're about to see with you. I think for all of you, your attendance here is an indication that you work on or around the healthcare compliance and reimbursement business unit within law and business. And as a healthcare compliance software provider to what are known as covered entities in the world of HIPAA and healthcare protected privacy information, we have an obligation to our customers and to their customers, the patients, to protect private health information, and it's a very serious and important obligation that we have, and that's why we're all here today, because in your work you may very well encounter, come close to, see, or be exposed to protected health information, and the information we'll share today will discuss a number of different things, but one of the more important issues is how to treat that information and protect it, and what to do with that information if you come across it in the course of your work. Our product is not like an electronic health record where the PHI, as it's called, is apparent and available to everyone in large quantity. Our product is, with ComplyTrack, does not store that information generally, but it is available occasionally, and we need to make you aware of what to do. I want to introduce or acknowledge, I guess, really three people here on the call. First is Leanne Foltz. Leanne, as many of you know, has been with Wolters Kluwer for 6 years, I believe, as a CRC in the healthcare compliance and reimbursement, formerly known as MediReg's business. She's a graduate of the University of South Carolina Law School. She's got 20-plus years of healthcare compliance experience, both as a compliance officer and as a practicing attorney. And in the last 4 months or so, she has been in an acting compliance manager role with our group, and she's been critical in the creation of the materials that you're about to see. So I want to thank her. Janet Levy, our corporate counsel, also is on the phone and listening in, and Janet, too, has been instrumental in supporting our group throughout the last, well, for years and years, but certainly since the ComplyTrack outage that took place earlier in the year. She has been a constant source of support and counsel and expertise, and we very much appreciate having her supporting our business. Our presenter today is a gentleman by the name of Kirk Nara. Kirk is a partner at the Washington, D.C. law firm of Wiley Ryan. And I'm going to just take a minute to share some of the accomplishments that Kirk has in his career, so you know that he knows of what he speaks, as they say. Kirk specializes in privacy and information security litigation. He works in a variety of industries, but healthcare and insurance are two of the most important ones, focusing primarily on compliance issues. He works with a number of different healthcare industry participants to develop compliance programs and defend against government investigations into those clients' practices. He has been named the co-chair of the Confidentiality, Privacy, and Security Work Group, a panel of government and private sector privacy and security experts that advise the American health information community on privacy and security issues, specifically arising from health information technology. He also serves as outside counsel for a number of different corporations, like Wolters Kluwer, on matters that involve the Health Information Portability and Accountability Act, also known as HIPAA. And we're really very, very lucky to have someone of Kirk's expertise and experience, and just good nature, and someone who can speak to laymen in very understandable and approachable ways. It's been a great pleasure to work with him. So at that point, I'll turn this over to Kirk, and he's going to walk us through the HIPAA training presentation today. This is being recorded, as Lee said, and we will have it available for replay if anybody is interested in doing that. So Kirk, why don't you take it from here?
Thank you, Tim. Thank you, appreciate that. And just for the record, there's no truth to the rumor that the sad-looking guy at the left corner of the slides is not me. Just be clear about that. I'm not sure where that poor guy's picture came from. All right, let's go to the first slide, Leanne, and just give people a sense of what we're going to be covering today. As Tim indicated, the purpose of the session today is to really make you familiar with the obligations that your company has in connection with patient health information, information that you may have access to, be using, et cetera, in the course of providing services to your healthcare industry clients. We're going to be focusing on the HIPAA rules related to privacy and security. We're going to talk about how these rules matter to your business, what your obligations are, how it affects what you do on a day-to-day basis. We're going to talk a little bit about what the information is, what kind of information you need to be protecting, and talk about appropriate steps to protect the information. As Tim indicated, I mean, unlike a lot of service providers to healthcare companies, your company doesn't do a whole lot with the information. I mean, there are companies whose job is to work with personal health data and protect health information and to manipulate that data and to use and disclose it on a regular basis. That's not really what you guys do. So in some ways, the obligations that you have may be somewhat easier than other companies in this industry. But I do want to focus on what you do need to know, what you do need to do with this information, and how you need to protect it. We're going to talk a little bit about the consequences. And again, I don't want to, that's not to scare people, but that's to make you cognizant of the fact that this is important. This is important to your business. It's important to your clients. And there are, in fact, risks and consequences or there can be risks and consequences if things go wrong. I'm not going to oversell that, but it is important to be aware of how these rules fit into your obligations and how they affect your day-to-day relationships with your clients and potentially with regulators as well. And we're also going to talk a little bit about specific data security standards, which are standards for the most part that apply across the Wolters Kluwer business, but are particularly important in this business where there are both risks because of the data involved and specific requirements that come out of these statutes. So let's move on to the particulars. Leanne, we can skip this slide and just go into the next slide. What is HIPAA? When we talk about HIPAA, we're talking about a federal statute from 1996, the Health Insurance Portability and Accountability Act. I give a lot of presentations on this topic, and I say to most audiences who are dealing with these issues that the most important thing I will say to you today is how to spell HIPAA. It has one P. It's HIPAA. in fact, I got one this morning. I get communications from all kinds of people who try to sell me their sophisticated HIPAA services, and they don't know how to spell the thing they're selling to me. So it's sort of a red flag that you don't know what you're talking about if you spell it incorrectly. The HIPAA statute dealt with a wide variety of issues for the healthcare industry. It dealt with something called portability. That's the single P in HIPAA, which is, when you change jobs, you can take your health insurance coverage with you. That's not what we're going to be focusing on today. We're going to be focusing on some particular offshoots of the HIPAA statute, mainly the HIPAA privacy and security rules, which are federal regulations that deal with the privacy, security, and confidentiality of protected health information. So you'll hear references to HIPAA. You'll hear references to the HIPAA privacy and security rules. You may also hear references to something called the HITECH Act. The HITECH Act was a different federal law that was passed in 2009, and it made some changes to the HIPAA privacy and security rules, or more accurately, it led to some changes in the HIPAA privacy and security rules. We're going to be teaching you just about the rules in general now, and there's a sort of full set of requirements. You may hear your clients talking about HITECH and the changes coming from HITECH. mainly just because that's the most recent set of changes to these rules. Let's go to the next slide, please. Let's talk for a minute about why this is important to your company. As Tim indicated in his introduction, there are certain kinds of entities who have always had to follow the HIPAA privacy and security rules. Those are called covered entities. We'll come back to that in a second, but those are basically the hospitals, the healthcare providers, health insurers, people in the healthcare industry who are covered by these rules. All of those companies use service providers to help them provide services. That can be companies like yours. They can be accounting firms. They can be consulting firms. They can be technology firms. They can be billing services. There's any number of service providers. And when the rules first went into effect back in 2003, those service providers had to have a contract with their clients that spelled out what their obligations were, but the service providers, and we call them business associates in this context, the service providers just had to follow the contract. They weren't subject to the law directly. That made it was still important to your companies because it was a business obligation, but you didn't have specific compliance or enforcement risks. Now, as a result of the high-tech law that I mentioned earlier, companies like yours that provide services to hospitals and other kinds of healthcare companies now must comply directly with the law, and you face, therefore, obligations that are both in your contracts with your clients and spelled out in the law, and that means you have both legal obligations and legal requirements as well as business needs to protect all of the data that you have. So this is now not only a business and commercial and contractual issue, but it's a legal compliance issue where your company is subject to enforcement from the government if you don't do the things that you are supposed to do. Let's move on to the next slide. I want to give you a sense of just some of the key terms that we use in connection with these rules. And again, these terms are important both in terms of helping you understand how you comply and how you do what you're supposed to do, but it's also important because you'll be talking to your clients and your customers about these issues, and they're very familiar with these terms because they use them all the time in the course of their business. So the information that we're talking about, the acronym is PHI, which stands for Protected Health Information. There's a long list of data elements that qualify as protected health information, but for your purposes, it is essentially any identifiable information that you have about an individual patient of one of your customers that you receive, store, or have access to in the course of providing services to the customer. So any information that's in the ComplyTrack system, it's stored there, it's sent to you as troubleshooting, it's used by you in the course of providing services, that's all protected health information. That obviously includes information that is about people's health. They have diabetes, they have this condition, they have that condition, but it also includes anything else about that person, even information that isn't really about the health, that's just, it's about them. So that's their name, that's their address, that's their, social security number, etc. So all of those materials, all of those pieces of information are things that you have to protect under these rules. That applies to protected health information if it's verbal, if it's electronic, if it's on paper. All of that information is protected by these rules. So let's go on to the next slide, please. All right, and a couple of other important terms that we're going to be using. So covered entity is the term that applies to your clients. These are the healthcare providers or health insurers who are covered by these rules directly. Again, I realize that most of your clients are going to be hospitals or other kinds of healthcare providers. You certainly could, if you ever provide services to an Aetna or a Blue Cross Blue Shield or somebody like that, they're a covered entity as well. Business associate is the term that applies to your company. It is a service provider to a covered entity. And the contract that we're going to be talking about is called a business associate agreement. This is basically the contract that spells out the specific details of your obligations to your customer. Those contracts, as I said earlier, have been in place since 2003. Now many of the requirements are also imposed by law, but we still have these agreements in place with your clients that spell out particular details, and a lot of the contracts spell out additional details beyond the specific requirements of the law. Let's move on to the next slide, please. There are certain kinds of obligations for business associates that changed as a result of the HITECH law. And again, the HITECH law was passed in 2009. There were final regulations that went into effect in 2013. Those regulations are fully in effect now and apply to your company directly along with all other service providers. So under those changes, your company has an obligation to follow the HIPAA security rule. That spells out specific security standards. We're going to talk about that at the end of the presentation today. You're now subject to compliance audits and civil and criminal penalties in the same way that doctors and hospitals and health insurers are. You have obligations to notify your customers in the event of certain kinds of security breaches. We're going to talk about that in a few minutes as well. And then you also need to comply with certain provisions of the HIPAA privacy rule. Mainly they're the provisions that are spelled out in a business associate agreement. We'll walk through each of those requirements. But again, you have obligations under various provisions, and all of these legal obligations are relatively new. They are as a result of that HITECH law, and essentially you've been required to follow these legal obligations since September of 2013, so roughly a year ago. Let's move on to the next slide quickly and just mention, again, we're going to talk at different points about 4 different parts of the HIPAA rules. We're going to talk about the privacy rule, which is the rule that spells out how information about patients can be used and disclosed. We're going to talk about the security rule, which is essentially the more technical standards for the protection of electronic data, both in your systems, when it's in transit, etc. We're going to talk about the breach notification requirement, which is a new requirement that came out of the HITECH law. And then we'll also talk a little bit about enforcement provisions. Although, again, that's mainly just to make you aware that there is enforcement, that that's a possibility. But it's not something that I'm intending to scare you with. You just need to be aware that that's out there. And it's essentially a strong encouragement to pay attention to these rules and to act appropriately to protect the information that's accessible by your company. All right, let's move on, I guess, to let's skip this one and go to the HIPAA privacy rule slide with the first bullet point. So what the HIPAA privacy rule does, and let me just back up for 1 second. We're focusing today on training you to work in your job in connection with protected health information. This is obviously an obligation for your company as a service provider to your clients. You should be aware and just think about these principles because they protect you as a patient too. I mean, every time you go to the doctor or you go to a hospital or you have health insurance claims or anything like that, these rules are designed to protect you as patients and as individuals. And so I always think it's important when we're talking about privacy principles for people to understand that these aren't just obligations in your business setting, but the whole point of these obligations is to protect you. And so you should be aware of this when you're a patient. You should be aware of it when you go to the doctor or hospital. And you should just be, thinking about these rights that you have as patients as well, because these all are designed to protect you in the same time. So what this law does and what these rules do is set a national baseline standard on privacy and security for the healthcare industry. What that means is that there's a federal floor of protection. If there's a state law or another law that gives patients more rights or imposes more obligations on covered entities, they have to follow the tougher laws as well, but this at least sets a baseline for when there aren't any other laws that are out there. It creates general principles for how information can be used and disclosed. It gives individuals various rights, including the right to access your medical records, the right to amend or correct your records in certain situations, and it also requires a variety of administrative obligations on covered entities and business associates, including things like training, as well as written policies and procedures. So let's go to the next slide. Again, we've talked about the term protected health information. This is individually identifiable health information that's created or received by or on behalf of a covered entity. Now, this is a sort of technical definition, and I want to go through this, but again, what's important for your purposes is this is any identifiable piece of information about a patient of one of your clients. I think these definitions are important, but the practical effect is you need to protect this information, whether it says anything about someone's health or not, because you got it from your client because these people are patients of your client. So it's individually identifiable information, relates to individuals' past, present, future healthcare treatment or payment for healthcare. But keep in mind, that's from the perspective of your client. Your client has this information about their patients because these people are patients. That means that it's about their healthcare, even if you can't look at it and say, aha, I know they were in for foot surgery. That doesn't matter. If it's individual information about a patient, you have to protect that information. Let's go to the next slide, please. One of the key elements of any privacy rule, and certainly a key element of the HIPAA privacy rule, is what the requirements are related to how information can be used or disclosed. And what the HIPAA rules did is it basically broke use and disclosure into three categories. The first category is the sort of core element of being in the healthcare industry. And what the government said in this rule is that disclosures for these key healthcare purposes are essentially made with assumed patient consent or presumed patient consent. So again, this matters to your company when you're acting as a business associate. It matters to the hospital. It matters to you as an individual. When you go to the hospital, this kind of use and disclosure is made essentially with your assumed consent. The categories are called treatment, getting treatment, healthcare treatment from your healthcare provider, payment, which is getting the costs paid for by the insurance company or whoever's paying for it, and something called healthcare operations. That's the administrative activities of running a healthcare business. You'll often hear the acronym TPO. Your clients will probably use that. Those disclosures, again, it's assumed that you consent to those. You don't really have a choice. It's sort of automatic when you become a patient or you become a beneficiary of an insurance plan. Then there are other categories we'll talk about quickly. They're not likely to be too relevant to your company, where disclosures can be made for public purposes, essentially where patient consent is irrelevant. The best example, I think, of that is something like public health purposes, where there's a law that says, you need to report certain kinds of infectious diseases. Again, that would mainly be the hospital doing that. But if they're going to have a law that says you report infectious diseases, you don't really care whether the patient consents or not. The purpose of that reporting is to protect the public health. And so the HIPAA rules create various categories where you can make disclosures for public purposes. The last category is basically everything else. And if it's something that's not TPO or it's not one of these defined public purposes, then you need the patient's specific permission. It's called an authorization in order to make that disclosure. So if, for example, you went to the doctor and or the hospital and you had a good experience there and the hospital said, you know what, we'd really like to tell your story on our website to show how, the great services we can provide. That's not a normal thing. That's not treatment. That's not payment. So they would need your specific permission to do that if you were a patient in that situation. So those are the rules for using and disclosing information. Let's go on to the next slide, although I'm going to do this one quickly because I sort of covered this. Again, the way this applies to your business is you have been hired as a business associate to assist your customers in connection with their TPO activities. You're helping them in ComplyTrack monitor their compliance with a variety of different obligations. That's part of the administrative operations of running a healthcare business. It's something that they could do themselves. They don't need permission from the patients because it's presumed consent, and the rules allow them to hire a service provider to do that as well. But that's how you're able to use and disclose information and to work with your clients. And again, you can use and disclose information to perform services for your clients, but there's only very limited reasons where you'd be doing it for your own purposes, and essentially so limited that you're going to need to get clearance to do that. We'll talk about those in a couple minutes. But again, you're performing very normal services for your clients in the course of this in the same way that an accounting firm would do, or a consulting firm would do, or a law firm would do. You're performing services as part of their TPO activities, and you're allowed to do that. You don't need to get any particular permission from patients to do that. Go on to the next slide. As I mentioned, there are public policy categories where patient consent is essentially irrelevant. There are a handful of disclosures that are required by law. I mentioned public health activities. Sometimes you have litigation involving, a hospital might be in a dispute with, its own vendor or a client or another hospital or whatever. There are rules for how healthcare information gets disclosed in that context. There are healthcare oversight and law enforcement activities. There are research activities. So, again, if I'm a hospital, I'm allowed to use and disclose information for these purposes. Your company is allowed to use and disclose for these purposes as well. It's just that it very seldom comes up. You're not, you typically don't have public health information. You're not the, you're not the entity that has to report an infectious disease. There's unlikely to be litigation involving information you have. It's possible. There are rules that apply if you get involved in a lawsuit there, but these again, you should know these are out there, but they won't come into play very often for your business activities. And in fact, if you do have a situation, again, I recognize that this is uncommon, but if there is a situation where you think it is appropriate for you to make a disclosure of patient information other than to your client, you need to go and get approval from the compliance manager, that's Leanne, in order to make that disclosure, because she knows the details of those requirements, and you'll be able to figure out if it's something you're allowed to do or not. Let's go on to the next slide, please. A couple of other principles that I want to mention. There's an overriding principle to the HIPAA privacy rule, which says that disclosures, I should say uses and disclosures, must be limited to the minimum amount of information necessary to accomplish the purpose of the disclosure. That's often shorthanded to the minimum necessary rule. Again, if you're a doctor, that means that if somebody says, well, I need to review, they're coming into the hospital for foot surgery, I want to see the records you have about their foot surgery or their broken foot, you give them those records, but you don't need to go back and tell them that they had measles 15 years ago. So it's a principle. It's not a hard and fast rule, and it shouldn't really impact your ability to do your business, but you should always think about when you're using or disclosing health information, do I need to do this? Do I need to do this much? Can I do it with less? If you need to do more, that's okay, but you always should be thinking about how you're going to deal with that issue. As I said, there also are contracts that remain in place with your clients. Those are called business associate agreements. There also in the HIPAA rules are very significant limitations on use and disclosure of healthcare information for marketing purposes. Again, that's not really an issue for you guys. That's an issue about what the hospitals can do and what the doctors can do and what the health insurers can do. Again, it affects you as a patient. It limits very much, you're not going to get a letter from a hospital trying to sell you a used car because that would be against the marketing rules. But just be aware of that. Let's go on to the next slide, which is a little more detail on the minimum necessary rule. Again, the minimum necessary rule kicks in where you're permitted to do something. You should always ask, how much information is needed. If you're not allowed to do it, minimum necessary is not relevant, right? You just can't do it. But for these appropriate purposes, how much information should you be using? again, you can always use and disclose what you need to do your job, but try not to go beyond that. Just don't say, oh, let's give them everything just because it's easier that way. That's both a violation of these rules and risky, because anytime you provide more information, there's a risk associated with it. So you can use PHI, you can look at PHI, you can disclose PHI where you need to do it for your business activities. You should always think about how much you're going to use. You should limit your access, use, and disclosure to that information that's needed to provide the service or to deal with whatever issue you're having in connection with your client. So just some examples. Let's go on to the next slide. You're obviously permitted to use PHI where you need to for your jobs. A couple of examples where that comes up. Customer service inquiries, implementation services when you're getting them trained, when you're getting them up to speed on using your products, other kinds of professional services you may provide your clients, technical development services. Now, as you're thinking about your jobs, you're going to realize that a lot of what you do with your clients does not, in fact, involve protected health information. It involves other kinds of information that the company may have. It may involve their policies and procedures. It may involve their requirements, their contracts, things like that. And again, you always want to be smart with that information as well, but these rules apply to health information about people, so always be extra careful in situations where you're dealing with patient information and you're dealing with information about individuals. And always think about whether you really need to use it. Can you use less? Can you protect it better when you have it? Those are all important elements of making sure not only that your company is complying with the right rules and complying with the provisions, but also is doing the right thing by these individuals and by your clients. All right, let's move on to the next slide, and we can actually skip this cover slide and move on to the details of the security rule. So we've been talking for the last few minutes about the HIPAA privacy rule. There's also a HIPAA security rule, which spells out specific administrative, physical, and technical safeguards to protect the PHI that you have. The privacy rule is sort of the rules on what you can and cannot do with the information. The security rule is how you physically protect it in your systems, in your files, in your buildings, when it's on mobile devices, when it's on laptops, when it's transmitted, etc. The idea is to ensure the confidentiality and privacy of PHI. They don't really mean guarantee it, but you're trying to protect it. You're protecting against threats of unauthorized use or disclosure, and you're generally safeguarding the information from inappropriate access, use, or disclosure. So this is how you protect the information that you have. Again, your company protects your systems generally. There are lots of reasons for every company to protect their computer systems, to protect their physical layouts, to protect their buildings, but these are essentially specific rules that spell out what you need to do in the context of protected health information. So let's go on to the next slide. In your jobs, you are hopefully trained and exposed to the variety of security standards that apply across the business. Obviously, you need to follow all the corporate, physical, and technical security policies, and that's for both PHI and for any other kind of sensitive information that's stored on your networks. So that when you're dealing with electronic PHI, and that's the phrase ePHI you'll often hear, that's electronic PHI, it's governed by all the Wolters Kluwer security standards and policies. That includes things like your password policies, when you need to change them, what the password needs to look like, how you secure your user IDs and passwords, how you access information, etc. So all of those are important kinds of security safeguards. Let's move on to the next slide. The focus of the security rule is really on electronic information, but that doesn't mean you don't pay attention to paper information as well. So you always have to protect physical hard copies as well. You should make sure that you're not just leaving information around. That's both in your offices and when you're outside the office. It's amazing to me how often we have security breach cases where people just leave files in places. One of the first HIPAA penalty cases involves some sensitive medical records that were being taken home to work on them, and the guy left them on the subway. Don't do those kinds of things. Make sure that you're protecting the information. Again, that's both information that's physical on paper and information on your computer screens. You got to make sure if there's information on a laptop, it's protected. Protect your laptop, encrypt it, lock it, close it down, all those kinds of things. You should discourage your clients from faxing you documents that have confidential patient information. I say discourage because it's not a prohibition. It's just not a very smart way to do business. So you should discourage them. It's really not ever going to be necessary for them to fax it. It may be something, I don't think it's worth picking a fight with a client who's determined to fax you something, but you want to discourage it. You want to make sure they know about the alternatives. You want to give them alternatives, secured emails, things like that are other protected ways of sending that information. Let's go to the next slide that sort of continues this theme. Again, so you really you seldom need hard copies of documents in order to help your customers. And if they need to send you something, if it's a screenshot, for example, that you need to look at, often they can take off the patient information. I mean, deleting the patient information, obscuring it, protecting it, just means that there's no risks associated with it. If you eliminate the information, it's not a problem. So, again, you should only get information that you really need to help the customer or solve the customer's problem, and be aware of these different options for getting information to you so that you can help out your customers. Again, you don't want to make it hard for your customers, but you want to make sure they know how to protect it and how they can get information to you in a protected way. You also need to make sure that you dispose of information that you have effectively. That means hard copies. That means deleting things on your electronic systems. Documents should be shredded and disposed of following those corporate procedures for this. But again, you don't just throw stuff out in regular trash. Again, there's been some cases where, for example, some pharmacies just dumped out prescription information in their trash, and then somebody goes along and takes it. So make sure you're protecting information. And a lot of this is just being smart about the data that you have, being aware that you have it and taking precautions to act appropriately when you have that information and you need to get rid of it. Let's go on to the next slide, please. Again, you really should not be getting PHI sent to you via regular email or as an attachment to regular email. Again, it's not an absolute prohibition. It's just not a good idea for anyone. There's always better ways to do it. There are other ways to send you information. There's uploading data from a secure FTP site. Again, there's just better ways to get information to you. If somebody does send you an email with PHI, they didn't talk to you first or whatever, make sure you've deleted it. Make sure you've protected it. Make sure you've deleted it from your deleted mail folder as well. You need to empty those folders. And if you get something you're not supposed to have in the first place, again, it doesn't mean you did anything wrong at all, but if somebody sent you information that you weren't supposed to have or wasn't supposed to come to you, make sure that you notify the compliance manager as soon as possible so appropriate steps can be taken to deal with that. Let's go to the next slide, please. Again, not everybody who works in this business need to deal with either PHI or access to the computer systems. You should only be accessing a customer systems if you have a need to know specific information and you're using information to assist in a particular customer issue. Again, you always want to have the minimum data wherever possible, be exposed to less because less can go wrong. And you really shouldn't be getting broad access to customer databases unless they've been de-identified. De-identified is a term that means removing the individual identifiers. Again, you can just blank out a lot of fields, et cetera. But in general, always be thoughtful about accessing information, how much, how often, for what purpose. Just be thinking about that. I think you can synthesize a lot of these rules into a single instruction that says act smart in connection with this data. And that's both a little too cute and a helpful thought. I mean, always think about what you can do better. Getting less is better. Protecting it more is better. Disposing of it effectively is better. Always think about those provisions. Now let's move on to the next slide. One of the reasons that you want to protect this information, and one of the reasons that you want to be smart about what you have, is that there are now specific requirements dealing with what happens in the event of a security breach. Security breaches have always caused business problems, but now in certain security breaches, not only is there an obligation to fix the problem and you've got all kinds of potential exposure, but you also have an obligation, or at least your clients have an obligation, to notify patients in connection with certain kinds of security breaches. The rules also require notice to the government in most situations, and sometimes even to the media if the breach involves a big enough number. So there are consequences when there are security breaches, and so that's another reason why you want to protect this information so effectively. Your company's obligation when there is a security breach is to tell your client, your customer. It's the hospital that has the direct relationship with the patient, and it's the hospital's obligation to notify the patient, but it's your obligation to tell the hospital so that they can tell the patient if the breach is something that occurred in connection with your system. And in general, the standard says that if you have a security breach, notification to your client and to their patients is required unless you've conducted a risk assessment that demonstrates a low probability of compromise of the information. That's the phrase in the rule, low probability of compromise of the information. Now, for the average person just working at this business, your job is to tell the compliance manager about a potential breach, and we will then handle the investigation and the assessment. So you shouldn't be trying to figure out yourself whether this was a big thing, a little thing, sensitive information, etc. But ultimately, the standard for notification is going to come down to you tell the individuals unless you determine that there's a low probability of compromise of the information. So going to the next slide, if you learn of any potential security incident, you must report it immediately to the compliance manager. I can't tell you how many situations I've been involved in that have been made way worse because people were simply too slow in notifying. It's always better to notify quickly. You can act quickly. You can fix problems. You can mitigate harm. You can stop the bleeding on these issues. You have a variety of obligations that kick in right away, many of which can make the problem either much simpler or much worse if you don't do them. So you need to be able to act as quickly as possible, and that means getting information to the right people as soon as you can about any kind of potential situation, that wasn't supposed to happen, any security breach, any information being sent to the wrong place, etc. Let's go to the next slide, please. Thank you. So let's talk quickly about enforcement, and then we'll have a few minutes for questions and comments and any other discussion that we want to have on these points. As I said earlier, your company now has specific legal obligations under these rules. That is a new obligation. Until September a year ago, your obligations were only under a contract with your client. So your client could terminate your relationship. They could try to sue you, but you weren't subject to government enforcement. Now you are subject to government enforcement. And that means that you face potential civil fines and penalties and even potential criminal sanctions if there's a HIPAA violation. Now, I will tell you, the HIPAA criminal sanctions for companies are basically non-existent. The civil penalties are not, there's not an enormous volume of them, but there's a decent amount, and the numbers can be pretty significant. There are a variety of multi-million-dollar penalties for companies that have had problems. There's other kinds of sanctions, including more frequently corrective action plans and things like that. Individual employees who violate these rules can face a variety of sanctions ranging from employment sanctions. You can be fired if you do something wrong on this. In theory, you even have criminal penalties under HIPAA. It is important to know, A, there are criminal penalties under HIPAA, but B, where those penalties kick in is when you do things like steal information to commit identity theft, steal information to commit fraud, sell information to the media. Don't do those things. Those are bad, criminal, illegal things. Nobody has criminal penalties because they sent a fax to the wrong person or things like that. So, again, don't do stupid, illegal things because you have criminal exposure under HIPAA. But in general, just be aware of this. You need to follow your company policies and procedures. Again, if you don't pay attention to the procedures and you've been told about it and you continue to not do it, there's a real likelihood of getting fired for that reason. Again, follow your company's procedures. Make sure you pay attention to these rules. You also face lawsuits from clients. You face termination from clients. You face very significant cost and reputation issues if you have security breaches or other kinds of problems. So this is a real issue. This is an important element of your overall responsibility to effectively do your jobs and to act effectively in connection with your clients. If you cannot protect the data that you have from your clients, your business will not succeed. And so this stuff is particularly important in connection with patient information, but really what we're talking about is acting smart, acting effectively in operating your business, in protecting the information that your clients are relying on you to protect in the course of your activity. So with that, let me stop at this point. It's important to be aware of these rules. It's important to pay attention to the company policies. Again, your policies are not particularly complicated because you don't do all that much with the information, but you do have lots of information. You do have access to it. You have the potential to use it and disclose it in inappropriate ways. You have the potential for security breaches. You have real issues with security problems. So be aware of these and always try to think about these issues when you're dealing with patient information and other kinds of individual information that you have access to in the course of performing your job. So with that, why don't I stop and we can open it up for questions. I guess I haven't been monitoring the website. Are there questions that have been posted at this point, Leanne? Or
this is Lee here. There's no questions posted at this time. If you have any questions, please use the Q&A box located in the go to webinar toolbar there on the right hand of your screen. The only Kurt, the only comment we had was from Sandy. He just was kind of reminding folks that I think you mentioned something about deleting email, and since WK uses Exchange servers, they do back those up. So anything you delete doesn't necessarily mean it's been deleted.
Yeah, and look, I mean, that is important to understand. It means it's not, permanently, I mean, it's not right away permanently gone, but those backups are, they roll over time. Again, it's very hard to have a problem, something that's just, I guess you could lose the backup tape, but then it's a little bit of a needle in a haystack, but it's yet another reason why you shouldn't get the emails with PHI in the first place. So always think about that. I mean, that comment goes to show you that even deleting it is not completely effective. It's better to have not had it in the first place. And if companies, if you've gone through the right steps and, people haven't sent you those emails in the first place, then you don't really have to worry about it.
All right, now we have some questions rolling in.
Okay, great.
First one here is, how do we tell well-meaning clients not to send us screenshots that contain PHI? This happens to support.
Sure. Well, and again, I think there's a couple of pieces to it. If somebody sends you a screenshot, it doesn't violate the law. Okay? So again, I don't think you have to pick a fight with the client. I don't think you tell the client, I'm sorry, we can't help you. What you want to do is you want to make sure you make it as easy as possible for them to get the information to you in some other way. Either not send it to you, get a screenshot of something else, delete a field before they send it, or send it through one of the secure methods. And I think that, again, I guess what I would say is sort of a relationship issue is be helpful and make it easy for them, but if they don't want to hear it and they just want to send it to you, it's okay, but that then triggers your end of having to protect the information more effectively and being very thoughtful about what you do with that information, et cetera. I mean, for example, if somebody sends you a screenshot in an unprotected, otherwise unprotected email, you have it. Don't start sending that around to another 50 people in your company saying, hey, what do you think about that? You know, let's be smart even internally about what you do with that information. Every email you send around is going to have a trail throughout your systems, and you heard earlier about how you can't even delete that right away. So always be thoughtful about what you do with information you have. You don't have to be as thoughtful if you don't get the information in the first place. So if you can encourage, persuade, educate, very important. But if you get it anyways, again, it's not illegal. It just means that you've now got to protect it and you've got to think about what you're doing with it.
All right. Yeah, I don't know if you're monitoring questions too, but I'll just keep going unless someone else wants to redo the order. This one may be for the whole panel, actually. It says, do you know if the WK security policy that GSS, that's our Global Shared Services, publishes includes sufficient provisions that cover HIPAA compliance? And the sub-comment is kind of, the person thinks it does because of WK Health, which is a different unit.
Yeah, I mean, this is correct. Let me just jump in on that, which is that's a very astute question, and it's a very hard question to answer. For the most part, and we're actually in the middle of doing this review. We're not in the middle. We're mostly to the end, but we're in the course of doing that review, largely driven by some of the outage incidents that Tim referred to earlier. And you're doing two things. You're both evaluating the rest of the Wolters Kluwer policies and procedures to make sure they're good enough to meet HIPAA standards, and then you're making sure that your business activities apply those standards effectively. So I think the policies themselves with some tweaks are going to be, quote, good enough to be the paper, the sort of policy and procedure side of HIPAA. And then there's the additional challenge of making sure that your systems actually work that way and that you run your business in accordance with those policies and procedures. So the idea, and again, we're most of the way through that, is to make that all HIPAA compliant. And again, I think we're in pretty good shape on that, but we're not done yet, and we're much further along than where that was, 6 or 8 months ago.
And then Janet Levy was chiming in here too, Kurt, and says, one, it does not, just because WK Health has it. She said, don't assume it, and then we're going to have our specific policies. Janet, I'm going to see if I can actually get you into the speaker room here. And Janet, I made you a panelist. You can see if you can speak. I don't know if you're dialed in or just listening over the computer. All right, doesn't appear to be working. So I'll keep going here.
Hey, Lee, this is Tim. I'm going to channel my inner Janet here. I think one of the things that she would reiterate in Kirk's comments were that there really are these two different aspects to the compliance activities. And the written documentation, the policies and procedures, as Kirk said, we do have some in place from GSS and that do cover the corporation. But even in talking to Mohammed Lazar, who is the head of security within GSS for the organization, he would acknowledge that those policies are just very, very basic. They are not intended to really address some of the very specific and detailed issues associated with HIPAA privacy. Health may have their own on top of the GSS corporate standards. I'm not familiar with those if they exist or not. I'm sure that some do. But we really need to be worried about and really focus on ours for our business. And each business is different. They're organized differently. Their technical and security setups are different. Their servers are based in different places. There's a whole host of reasons why we can't take the generics. But the second thing that Kirk said that I would just want to reemphasize as well is just because the policy exists does not mean you're in compliance. It's all about being able to, your attendance at this training session is an example where, okay, we had a training session written. but did people come to it? Did they attend? Is there any? Did they learn anything? In terms of the security, are we doing audits of our backups and our recovery processes? Are we doing penetration testing on our external environment, making sure that we can't get through? Are we doing internal audits of some of our activities to make sure that we're in compliance? Those are equally, if not more important than the written policy, and so that's what we all have to attend to.
All right, another question here. It says, are there recognized organizations that provide a HIPAA compliance analysis and evaluation and advise us if our measures are complete?
I mean, short answer is yes. There are lots of them, and but that's also something that your business is in the middle of doing. I mean, there was a security consulting firm that came in and did some outside analysis and identified some things that needed to be beefed up. That's what Leanne has been working on. That's what Janet's been working on. That's what I've been working on. So yeah, there's lots of other organizations that you could work with if you were starting from scratch, and your clients work with different companies, and your clients have privacy and security offices themselves. So there's a whole field of people who are involved in HIPAA compliance. That was the sort of joke I started off with. I said I get pitched by those people all the time, and half of them can't spell HIPAA right, so I'm always a little skeptical of their ability to provide effective services if they can't spell it right. But yeah, it's definitely a hot field at this point, particularly with the high-tech changes that, again, expanded dramatically the number of people that have to follow these rules.
All right, another question here. It says, will our official policies and procedures be posted, updated, and accessible on an internal site?
So this is Tim again. The answer to that is yes. We are, as has been referenced, we're working on getting all of those finalized and finished and in a form where they will be sent out. Probably a summary of the policies and procedures will be sent out, excuse me, to everybody. And on that summary will be a link to the SharePoint site where those, at least now, perhaps using SharePoint, perhaps using ComplyTrack itself as the repository. But we're working on making sure that those are published and available, and we do a good job of making sure everybody knows where they can get it. You'll see at the end of the presentation an email address that goes to the compliance manager, Leanne, and we'll also obviously encourage people to reach out via phone or email or knock on a door and ask a question. It's really about communication, so we are going to do everything we can to make sure people have that information and know where to find it.
Okay, now in a somewhat related question, it says, are SOP documents available and ready for distribution to the customer-facing teams?
I don't know. I mean, standard operating procedure documents, I'm not sure exactly what that is referencing. So I'm not sure exactly how to answer that one. It's not triggering something for me that there's a set of standard operating procedures by role or department for this, but perhaps that's something we should consider.
Okay, Janet said that the person asking the question should contact you directly. This one looks like a pretty big question here. It says, how should employees handle situations where they see non-compliant practices in the regular course of their work? For example, say we did not have an adequate secure channel to transmit PHI, but management or the client did not want to expend resources to secure adequately. Is there an obligation to report? Is the employee potentially liable to criminal or financial penalties if they proceed?
Sure. I mean, let me start at the back end. I mean, again, don't steal information and sell it for personal use. Don't commit healthcare fraud. Don't commit identity theft. If you don't do those things, the sort of idea of an individual criminal exposure is just not realistic. If you have a situation like that, I would go in the first instance to probably Leanne. If Leanne's not there, go to Tim, go to Janet. But again, most of these situations, if it's something that's internal to your business, identify the problem and let's get it fixed. if it's a problem with a client or a situation with the client, and the earlier question about the screenshots is sort of one example. Your business does a baseline in the sense of the ComplyTrack product itself is basically you design that product and you sort of that's what you market to your clients. So the clients can't change that all that much. If there's some problem that arises in connection with a client, you think there's something that the client's not doing right. Again, let's bring it to the right people's attention. Some of those issues are going to be your client's problems and not yours necessarily. But again, let's let Leanne and Janet and me figure that out. And in other situations, I mean, you certainly could have identified a problem that we hadn't thought of. That's absolutely possible. If it's something that exposes you guys to risk because of something your client is doing, again, we need to know about that so we can respond effectively. There aren't going to be that many situations where you say, I'm sorry, we can't work with you anymore. I suppose it's possible. But the main thing is, the idea and one of the purposes of these trainings was to make sure you guys are thinking about these issues. And part of thinking about these issues is recognizing when you need to go to somebody who's really an expert on these issues. And so, if 2 weeks from now some issue comes up and you say, well, wait a minute, this is an issue, go to Leanne, let's get it fixed. And I'm sorry, not just fixed, let's get it answered. It may be that there's not a problem, or there may be an easy fix. If it's a hard fix, we got to do that too. But the main thing is to bring it to the right person's attention so that we can address it.
All right, thanks. I also have two questions that are kind of like procedural in nature. One is around do we have to escort our guests in and out of the office, and the other kind of related to office stuff here is how do we ensure that employees lock their computers?
Let me take the first part, and then we can may turn it over to someone else on the locking part. But I mean, look, you guys, again, if I'm a visitor to a hospital, there's sort of no way that I'm not going to be exposed to patients, right? I mean, you just can't do that. Then people still visit hospitals. In your business, a visitor shouldn't be exposed to any protected health information. I would not, take a visitor in, sit them at your desk, and say, oh, by the way, here's my computer, and here's how you get into the ComplyTrack system if you feel like browsing around. So that's a reason why you don't leave paper records around. You don't leave computers open. You don't leave stuff in the cafeteria. You don't, So in general, you don't need to, you guys have protocols for what you do as visitors on your physical plant because there are reasons to protect your physical plant just in general. But the PHI concern, again, you shouldn't expose the visitors to PHI in the normal course, but I don't know why they would be exposed unless you sort of do something really sloppy. Now, on the computer piece, on the locking, Leanne or someone else, I don't know whether I assume there's an automatic locking at some point, but again, there's just a training element to making sure people protect their computers for PHI being one of the reasons you protect your computers, but clearly not the only reason. Anything else to add on that, Leanne? Or maybe not. Tim, anything? I mean, I don't know exactly how the.
I think it may come back to the earlier question around standard operating procedures. Part of the security policies and some of the other procedures that we are creating will be to address some of these things. And again, as I said, there is a security task force, a work group that is evaluating all this and will be responsible for approving things. So that too will likely be part of the documentation, which is made available to everybody as it's completed over the coming weeks and months. And I would imagine that there probably is at some level a policy on that. I don't think we're going to get draconian in terms of enforcement, but we like any other organization, audits of that kind of information is certainly possible, and we will do that to make sure that we're in compliance with the policies that we write.
All right, another two somewhat related questions. It says, are we investing in any secure email for our business? And then another related, I guess, comment was, can ComplyTrack be used as secure email with clients, since it has some of those features within?
Yeah, it's really interesting, and we probably should have anticipated some of the technically oriented questions that are coming out of this presentation, and we really did not get somebody like Jason Bovee or someone else lined up to answer some of those questions, or Mohammed on the security side. So I don't know the specific answer I know we are changing our corporate email provider to a cloud-based solution, but I'm not sure specifically that I'm certainly qualified to answer some of the details there, but we can follow up with.
Lee, can we capture a record of some of these questions so that those technical ones I think, Tim, it would make sense to do a response to the people on the phone that spell out an FAQ or something.
Yeah, Tom, I was going to say, Tim Kurt, that's going to be my next comment. We're collecting all of these for a Q&A, and I can send them to Leanne right after this meeting. So I'll kind of brush over. There's a couple more little technical questions. But the last one that looks good is, was this being recorded, and do all employees and contractors need to review it as part of the onboarding process? If so, how will that be made available to managers?
So the answer to that is yes, it is being recorded. We may use it as the raw material for a slightly different version of something that will be put up on a learning management system with some Q&A built into the, as I'm polling or quizzing in terms of the content. But yes, there will be a asynchronous version of this training available so that as new employees are brought on board, as we engage with specific contractors, we can make sure that they've been appropriately trained, and we can document that. I can't remember the part 2 of that question, Lee.
Oh, it said, if so, how it would be made available to managers.
Yep. So again, I think as we take this content, this recording, and work with the folks in the training team to turn it into a recorded, asynchronous, again, learning event, we will, once it's complete, communicate with everybody about its availability, its use, and make sure everybody knows where to find it.
All right. That brings us to the end of the Q&A.
Great. I'll just want to thank everybody involved in this. I mentioned Leanne and Kirk, Janet, of course, Jason Bovee, and other members of the technical team have been very, very much involved and will continue to be so. And I want to thank each of you for attending today. Great questions and engagement. Look forward to working with all of you on this topic. It is one that is, because of our specific product and the kind of, we are existing on the outskirts of these issues and laws because we don't manage, as part of our product, vast amounts of PHI. But as Kirk referenced, it doesn't take vast amounts to get into a whole bunch of trouble and incur very substantial fines for the organization and reputational risk, et cetera. So this is really critically important to our business, and we hope that everybody was able to get something out of today's presentation. We'll follow up with some additional Q&A and FAQs, and then make available additional information as we go forward. Thank you all for attending, and look forward to seeing and talking to you all soon.